Good afternoon, everyone. We are so excited to have you join us for this webinar, which is one in many to come. Good afternoon, everyone. Based on compliance. We are so excited to have you join us for this webinar, which is one in many to come. My name is Jeremy Glauser. I'm the founder and CEO at eLuma Online Therapy. I will be introducing the webinar and the topic today. We are going to hear some great information about due process and Section 504 hearings. I'll introduce Jerry here in a moment. He's a good friend of mine, and I'm super excited to have him sitting here right next to me. So the agenda for today's webinar is going to be pretty straightforward. We're going to do a short intro. We'll talk about the webinar, give a little background about Jerry. Jerry will take 45 minutes and go into some great detail on the topic. And then we'll have a Q&A. At the bottom of the webinar screen, there is a button that says chat. Click on that, it will open up a chat, and then you can pose a question or a comment that will be visible to us as panelists. I will keep track of any questions that come in, and at the end, we'll take 5 to 10 minutes or the amount of time remaining and answer as many questions as we can. For those questions that we can't get to, we'll follow up and provide some opportunities to get answers for you. In addition, we are going to be providing a recording of the webinar as well as the slide deck after the fact. So those of you who are here will get that, and those of you who've registered will also get it. So who is eLuma? We're obviously sponsoring the webinar today. We are specialists in online therapy services. In other words, we license our services and our software. We partner with school districts across the country to bring productivity, monitoring tools, transparency tools, but especially compliant services and tools that will help districts create a great special education program across the district. We're focused on solving compliance issues. That's probably the #1 concern that we hear as we interface with all of you at conferences or as we go and visit with you. We're founded in 2011. We have a team of over 100 people, and we serve more than 4,000 students in 29 states. You know, enough about eLuma. We all know why we're here today. I'm going to move on and talk a little bit about the webinar. We sold out after only a week and a half of advertising the webinar, which obviously tells us this is an important topic to many of us, and we're excited for you to join us. We're also streaming this on Facebook Live as well as YouTube, so in the future you'll be able to access it that way. This is just one of our compliance webinars in a series of webinars, and we'll have many other topics that we address as we go into the future, so stay tuned. We're going to record it and send out the slide deck like I mentioned originally, so don't worry. Be here to participate. If you need to follow up, then you're more than welcome to. As a matter of fact, let me go back because I want to take a quick poll of those who are here as attendees, okay? Those of you who are here in our Zoom webinar will be able to see this poll, but those of you who are not in this Zoom webinar won't be able to see it. But I've just posted a poll up there. It asks, what is your position? Take just a second, choose an answer, and then submit. We'd be really interested in seeing who is here today. We have a couple hundred people in attendance, and it's always fun to see who our audience is. It looks like about half of our attendees are special education directors. Another 20% are coordinators. 20% of you would be classified as administrators. We have about 6% who are practitioners, and then the other large group of attendees is 15% who are teachers. A really good diverse group today. We're excited to have you. It's a fun little fact. Now we're going to introduce Jerry. I want to get into the topic of why we're here today. Jerry is a good friend of mine. I've only known Jerry for a relatively short while, but I'd say we get along pretty well, don't you? Don't you, Jerry?
Yes.
I think so. Jerry is very distinguished. If there's anybody who knows his stuff about special education, due process, 504 hearings, it's Jerry. I don't know if you'll find anyone more knowledgeable. He has a rich background as a special educator, as an administrator, a consultant, and he served as the national president of CEC, the Council of Exceptional Children. And I know Jerry is deeply passionate. You can see it in his manner and his energy. He is an incredible individual. And today he's brought a very rich presentation for us. It's got a lot of great content. So I hope you've come ready to feast at Jerry's table. So Jerry, I'm going to go ahead and turn this over to you, and let's get into the meat of why we're here.
Thank you, Jeremy. And thank you for being, those of you out in the audience, thank you for attending today. Let's start off with this slide showing a quote by Martin Luther King: "Injustice anywhere is a threat to justice everywhere." This was prior to some of the federal laws we now have. And I'm going to briefly discuss some of the federal laws. It won't take too much time, but we have what I refer to as the Civil Rights Acts for persons with disabilities. There's the Rehabilitation Act, which was signed by President Nixon in 1973. It was replaced a previous act. Then we have what we call IDA, Individuals with Disabilities Education Act, which was signed in 1975. At the time it was signed, it was referred to as Education, the Handicapped Act. We'll talk a little bit more about that. And then in 1990, another law was passed, the Americans with Disabilities Act, which brought the entire community into being conscious about the rights of persons with disabilities. At the time that the Rehab Act was being enacted, it was introduced by Senator Hubert, he was senator at that time, Hubert Humphrey of Minnesota, and he mentioned that we can no longer tolerate the invisibility of the handicapped. We need to, they have an entitlement, and we must see that every child, gifted, normal, and handicapped, has fundamental right to educational opportunity. And as you know, Senator Humphrey went on to be vice president. The Rehab Act, which was signed in 1973, was actually enacted right after the First World War. It was originally called the Vocational Rehabilitation Act. It was intended primarily for veterans of the war. As it says, it replaced the Vocational Rehabilitation Act. The 1973 version extended the authority to the states to provide vocational rehabilitation services, and also focused on education, and also worked with those with the most severe handicaps. Established within the Department of Education programs that were specifically for handicapped individuals, as they were termed at that time. Several years ago, I wrote an article for a journal, and I entitled it The Levi Act. And the reason I entitled it The Levi Act was that if you go into a men's department store and go to the Levi's section, you can find Levi's 501, 502, 503, and et cetera. Well, within the Rehab Act, there are 8 sections. 501 requires any federal agency has to have an affirmative action plan to hire and promote qualified individuals. 502 requires that all buildings constructed with federal funds have to be accessible to persons with disability. You go to any new post office, any federal building, whether it be whatever government it is, then it has to be accessible for persons with disability. Section 503 covers government contractors, those agencies that are receiving contract from the government, such as universities or businesses. Any business that gets a federal contract must have a program or provisions for hiring, assigning jobs, promoting, etc. Section 504 is what we're going to be talking primarily today about. It specifies that no handicapped person shall be excluded from participation, denied benefits, or be subject to discrimination under any program activity receiving federal financial assistance. And education receives federal financial assistance, and that's how it applies. Section 504 provides that also that attorney's fees can be awarded when a parent files a complaint or goes through a hearing. If they prevail in that hearing, they can be awarded attorney's fee. Section 504 is one of the more recent additions. It talks about electronic information that has to be available, such as the telegraph, the TDD for the deaf. So that is also part of this. IDA, or Individuals with Education Act, Disabilities Education Act. Originally was called the Handicapped Act. It supports state and local agencies protecting the rights of individuals with disabilities, focusing on infants, toddlers, children, and youth with disabilities. It was amended in 1997. The new name was Individuals with Disabilities Education Act. The reason that was changed was, first of all, it puts the person first, individuals with disability, not a disabled person. It also used disabilities as opposed to handicap. The term handicap now is no longer politically correct. And for some who might be aware that the term handicap actually came from the idea that putting money into the hand of a beggar, from hand or into the cap of a beggar. So the term handicap is envisioned as someone begging. It enables and supports effective programs and services, early intervention to our children, preschoolers, infant programs, special education, and related services such as the eLuma provides as well. Before IDA was enacted, and there was only 1/5 of all the children with disabilities were being served in education. The Americans with Disabilities Act, which is the most recent one, 1990, basically extended all these provisions to the general public, such as public restaurants, anything in the community. They have to be accessible for persons with disabilities as well. And it uses the same definition as Section 504 does. It was also amended in 2009 to broaden the scope of it. Briefly talking about the Rehab Act. It originally was geared for job opportunities and training. It was only in the 1980s that it became more applicable to schools. It was always there, just that people weren't aware of it. But it was primarily for those individuals who were looking for work, housing, transportation, etc. And it still uses the term handicapped. It has not been changed. Maybe sometime in the future, they'll change it to persons with disabilities. It focuses on non-discrimination. And that's primarily what the point of it is. You cannot discriminate against a person who has a disability. Any program that receives federal funds cannot discriminate. And they must allow those persons to enjoy the benefits that are available to non-disabled students and individuals. Unfortunately, Congress didn't provide any fund. This is one of the drawbacks of the Act. School districts must implement the programs, must make accommodations. There are no funds for that, though. And it's enforced by the Office of Civil Rights, Office for Civil Rights. This isn't working. Okay. The definition of disability is very broad under Section 504. It has 3 different categories. A person has a physical or mental impairment that substantially limits a major life activity. We're going to talk about that a little bit more in a minute. Or has a record of such an impairment or is regarded as having such an impairment. Now, the Office for Civil Rights came out with a memorandum in the early 1990s to stipulate that parts B and C primarily were geared for employment purposes. So we're going to talk more about Section A. Physical impairment. This shows you a list of some of the physiological disorders that are covered. Neurological, muscular, respiratory, etc. Then under the mental disorders, you have mental retardation, etc. Those in column 2 under mental impairment would be qualified for special education. But all students need to be served and not discriminated against. Major life activities, very, very broad. It's self-care, manual tasks, etc. You see the list of them there. As I mentioned, the record of impairment, regarded as an impairment, primarily is for employment purposes. Some have tried to apply this to individuals in the school system, but really you need to look at the adults who are being served. As I mentioned, IDA, Education and Handicapped Act, is a federal law covering special education. It does provide funding. It does. That is one of the benefits. Now, when it was enacted, the law said it would eventually provide 40% of the funds for special education. To this day, we still have not gotten to that point. And at that time, 1 million children with disabilities were excluded from public education. My mother was an elementary teacher in a rural community in Iowa. And she discovered in the 50s, she discovered there was a young boy who at that time was referred to as mongoloid. He had Down syndrome and he was not allowed to attend school. So she voluntarily was tutoring this young man because public school would not accept him. Those are the students we now serve through our special ed program. It also established criteria for eligibility. When you look at the law, for those of you in special ed, you know there are 13 categories that qualify a student for special education. It also recognized that there was a need for teachers. So one of the parts of the law covers training program. It set procedural protections, which we're going to talk about more primarily for Section 504, and it's enforced by the Department of Education. ADA briefly covers all those, the public association. Title I covers employment, Title II, government activity, transportation, etc. The education is more, the Office for Civil Rights focuses on Title II, state and local government activities, which are your schools. Just to quickly compare the three laws, the Rehab Act says prohibits discrimination on the basis of a disability. If you notice over on the last column, the definition for ADA is the same. In the middle, we have IDA, which states assistance to state and local education agencies to guarantee special education and related service to children with disabilities. Who's protected? Again, any person with a physical or mental disability is protected under the Rehab Act. The IDA covers the 13 categories, autism, hearing impairments, etc., that are specified in the federal law. ADA uses the same definition for as does the Rehab Act, but also it stipulates that under ADA, a person must be qualified for the program or the service of the program. So it's not just open to them, they have to be actually qualified. Free and appropriate public education. FAPE is a term that is one of the acronyms that we hear frequently. Under the Rehab Act, FAPE is provided for all students that are, and they must be provided programs that are comparable to the students without disability. FAPE under IDA is also provided in our programs, related services, accommodations that are made. FAPE is not directly applied through ADA because it really was not intended for schools, but it can apply to schools. It also can apply to the employees, not just to students. Funding. This is the big question. Rehab Act, there is no funding. Districts have to pay for this out of their general funds. IDA, there is funding, not adequate funding, many feel. And then ADA, there's no funding. Although under ADA, if there are accommodations being made or adjustments being made for transportation or architecturally, then there are tax credits available. Due process. Each one of these does require that due process be provided for the participant. Under 504 or the Rehab Act requires educational agencies to provide impartial hearings for parents who disagree with identification, evaluation, or placement. And I want to emphasize those three items: identification, evaluation, or placement. A hearing must focus on those three items. Frequently, hearings are requested, but they do not pertain to those three. IDA delineates the specific requirements, and if you go to the law, you'll find out very, very specific requirements into providing the due process for parents with, of children with disabilities. The ADA does not delineate any specific due process procedures, although parents do have, or individuals do have the right to have remedies under the Civil Rights Act of 1962. Now, interesting enough, too, you need to be aware that right at this present time, there's a bill before our Congress that has actually been passed by the House of Representatives. It's HR 620. You may want to kind of check on that, which changes the process by which people can file for a complaint or for a hearing under the American Disabilities Act. It actually is making it more difficult. And the reason for that is that in recent times, there's been a number of complaints have been filed frivolously, We had an attorney in California who filed over 250 complaints under ADA, and he never went to court on any. They were all settled out of court. So keep an eye on HR 620. The Rehab Act covers the procedural safeguards. Now, this is very general. And if you ask about a hearing under Section 504, and I'm asked as a hearing officer frequently, it's a very general term. There's only one section of the law. 104.36 is one short paragraph that states that parents have the right to file for a hearing. It also states, because it doesn't tell you how you proceed there, but it does stipulate that compliance with the procedural safeguards of the Educator Handicapped Act, again, IDA, is one way to meet these requirements. But it doesn't tell you how you are to conduct a hearing. It's very broad. Now, the Office for Civil Rights has answered some questions. I'm going to cover a few of them regarding procedural safeguards, because all individuals have a right to have procedural safeguards. Basically, what that means is you have a right to have a hearing, you have a right to hear your complaint, you have a right to have your problems resolved. The Office for Civil Rights put out a series of frequently asked questions, and you will find this. I have later in here, I have a series of resources that are going to be available to you. And one of those is the frequently asked questions. It's 42 questions that the Office for Civil Rights had. I wanted to cover some of those that were specifically about due process. Must the recipient school district obtain parental consent prior to conducting an initial evaluation? You can't just take a student and put them into a program, either special ed or whatever it may be, because OCR has stated that you must obtain parental permission for any initial evaluation. If a school district suspects a student has a disability, they have to get parent permission to go through that. So sometimes you'll go this route through the student study team process to determine if a student has a disability. What form is the consent is required? The district doesn't, the law doesn't stipulate what kind of form is needed. But what you need to do is, within your school board policy, you need to develop a form. And there will be a sample within the resources that I will be sharing with you. What can a recipient school district do if the parent withholds consent to provide these services? 504 does provide that you can take the district can take the parent to hearing. However, that's not necessarily true with IDA, but if you as a district have gone through the process of evaluating a student, you find the student eligible, has a disability, and you want to make accommodations or provide a program for that student, if the parents do object to this and are not in agreement, you can take them to a hearing. To be very honest, I have not heard of a district that's taken a parent to hearing. While procedural safeguards are required, you must establish programs, and this again is should be within your board policy, to establish procedural safeguards as to how to allow parents to have opportunity to review the records, they have an opportunity for a hearing, and they can be represented by counsel, and they have a review procedure. What's the recipient school district responsibility to provide the information? Again, look at your board policy. Section 504 requires districts to provide notice to parents explaining any of the evaluation procedures and placement decisions. So in advance to evaluating the students, the parents must be advised to be aware of what their rights are and what they are going to be covering. Oops, excuse me. There was one question. Yeah. Final question that they had was, is there a mediation requirement under Section 504? There is not. That doesn't mean you can't. I have actually served as a mediator prior to becoming a hearing officer, because I worked for the Los Angeles County Office of Education. I could not be a hearing officer in any of the districts, but I could do mediation for them. But it's not a requirement under 504. We're going to talk briefly about the hearing procedures, the points that need to be considered. When a parent requests a hearing, you know there's a problem. And the hearing can be utilized to resolve some of these differences. that cannot be done through less formal procedures. Hopefully that you can resolve these without going to hearing. Frequently when I get a request for a hearing, within a day or so, the districts and the parents have gotten together and resolved the problem, because that's the best way to do it, because that way they can discuss what they're going to do. And you must realize too that the students are going to be with them for many years. But it's an opportunity to present objections and reason for the objection to the decision. Sometimes it's just merely a matter of if a student does have a 504 plan and it's not being implemented. This can be a reason for an objection or a reason for a hearing. It may be called at the request of the district or the parent or the guardian or a surrogate parent. So any of those can request a due process hearing. May be initiated to resolve problems related to, again, emphasizing eligibility and related procedures, the procedural safeguards, the provision of the FAPE. And it must be presided over and decided by an impartial hearing officer. Now, an impartial hearing officer, and that's what I do, is, and the Rehab Act does establish. Actually, some of this, the material that I'm going to be covering next, is actually from Dr. Perry Zirkel, who's an attorney who does a lot of work in terms of special ed and the Rehab Act. But an impartial hearing officer must not be an employee of a public agency. They can be an administrative judge, or they can be, but they cannot be employed by a public agency. Must not be a member of the state rehab council if you have a rehab council in your state, as described in section 105 of the law. Who has not been involved previously with the Vocational Rehab Act of the applicant or eligible individual. In other words, if I were asked to be a hearing officer in a case, I could not have had a relationship either with the student or possibly the district or the family. It cannot be as far as providing services. The hearing officer must also have knowledge about the vocational rehabilitation services, the state plan, and the federal and the state rules governing the provision, and who has no financial or personal interest in what the result may be. All parties have the right to present their, it's like going to court. All the parties can present their evidence. They have documents, and one of the issues at each hearing is the documents must be presented ahead of time. In my case, the way I do it, I have the documents presented at the time of the hearing. Under IDA, or the special ed laws, the evidence has to be presented 5 days in advance. I do not operate that way because I feel I want the evidence the day of the hearing so I can never be accused of forming a bias. So the evidence, each party has a right to provide evidence. Each party also has a right to bring in outside expert testimony. They can ask private individuals, they can be represented by legal counsel, but they can bring in witnesses, either party. The parents can bring maybe a therapist who's worked for them, someone that knows the student, knows the services, or knows why they are in violation. Both the district and the parent can be represented by legal counsel. And if there's a situation where there's a language difference, then an interpreter shall be provided. If it's other than English, then whether it be Spanish, Vietnamese, whatever the other language, the interpreter should be provided. And the parents who are involved have a right to have the student present at the hearing. Now that needs to be aware, though, that the student must be able to present himself, him or herself. But they do have the right to have the student here there. And I have had hearings where students have actually testified. The hearing is open to the public unless the parents request that it be a closed hearing. I have never had a closed hearing. All of mine have been open. And they have access to and copies of the student records. You cannot deny a parent the right to have a record of their students' records. The decision. This is the hardest part of a hearing, is that the hearing officer must render a decision within 10 days following the completion of the hearing. And I say it's the most difficult because the hearing is typically recorded auditorially. The hearing officer then must go over that hearing word by word to get all the nuances, all the statements that have been made to be sure that it's accurate. When I do a hearing, it takes me hours to go over the hearing. I'm currently in a hearing now. We've already had 2 days, which means I have 12 hours of testimony I'm going to have to listen to. Notification will include a statement that each party may appeal the decision. If they are appealing the decision, they have to go through the court system. Otherwise, the decision of the hearing officer will be binding on all parties. So the decisions that I come up with is it applies both to the parent, the family, and to the school district. Just some comparison. IDA must provide an impartial hearing for parents who disagree with identification, and it requires written consent. Much of this is very similar between the two, and it describes specific procedures. If you go to the federal law and go to the due process section, you find it's very specific in terms of timelines, people, etc. So it's very specific as to what is to be covered. And the impartial appointee selects a hearing officer. It's not the, it has to be, in California, it's the State Department of Education. I don't know what in your state, but it is not up to the parent or the district to select a hearing officer. An impartial person selects that. Also, a difference is that under special education, you have stay put. In other words, the student stays in whatever position they are, placement they are, until the proceedings are resolved. This is applicable to special education. It does not apply to Section 504. And the parents must receive 10 days notice to any change in placement. The IDA is enforced by the United States Department of Education, the Office of Special Education Program. Similar situation under Section 504, that the hearing is provided for parents who disagree with identification, evaluation, and placement. It does not require parental consent to have a hearing. In other words, a district could take a parent to hearing without the parent consent. It requires that the parents have an opportunity to participate in and be represented by legal counsel. The district also can be represented by legal counsel. And this is one of the major differences, is that the school district appoints the hearing officer, as opposed to under IDA, it's an outside agency that appoints the hearing. The school appoints the hearing officer and also must pay the hearing officer. And there's no stay put provision in this. In other words, if the student is being moved, they can be moved. The district is not required to keep them in the present placement. Does not require that parents are notified prior to a student's change of placement, but the parents are to be notified. Now, within your school district policy, board policy, you need to be sure you cover all these issues. And this is enforced by the United States Department of Education, also the OSEP, and the Office for Civil Rights is actually part of the United States Department of Education. One of the major issues that come up in a hearing are the compliance issues. And I think it's very important for you to be aware, as an educator, how do you get into this hearing? What happened? Why are we sitting here today with a parent? So I'm going to review some of the most common issues that come before me as a hearing officer. First of all, the development of a plan without appropriate evaluation. You should not, and that's why you get the permission to do the evaluation, is to evaluate and base the program specifically on the needs of the student. When you develop a 504 plan, you're addressing the student's needs, how they can be resolved, how the services can be provided. One of the major failures is to document the team decision. The team may make a decision and just enact it, bring it about, but they don't. This is not typical, but sometimes a failure to document the team decision can result in a hearing. Failures or refusal to consider evaluation by outside professionals. This happens both under Section 504 as well as in special education. Parents have had an evaluation done by an outside therapist, maybe a speech specialist, a psychologist, a medical person, and the district may disregard that. And that's another reason for a hearing. Failure to limit the home and hospital instruction. Again, you need to look at your board policy. You cannot limit it merely just to 1 day a week or whatever, but you have to specify what services are being provided at home or in the hospital. This is another common limitation that results in a hearing. Another one is a failure to transfer 504 documents. When students move from one district to another, sometimes the documents get lost. Consequently, the parent can request a hearing. Or failure to respond to evaluation requests. Parent may request an evaluation and the district just ignores them. And this can end up resulting in a hearing. Failure to access attention deficit disorder, hyperactive disorder with appropriate instruments, not just severe language disorder. And there, in the resources I'm providing for you, there is a letter from the Office of Civil Rights, Department of Education, that specifically addresses attention deficit disorder. It's called a Dear Colleague letter. So you'll find more about that later. Oops, it's not moving. More issues. Failure to implement a plan in a regular education setting. In other words, the 504 plan that you have developed stipulates maybe extra time for tests, maybe the ability to use a calculator in a math program. But these are all accommodations that are specific for the regular class setting. And that often ends up in a hearing. There was a lawsuit in one of the southern states where the parent went to court because the regular education teacher was not implementing the 504 plan. As a result, the teacher was actually fined because they had gone to court. But this is one reason that I frequently will have a hearing, is that the regular education teacher is not implementing the 504 plan. So it's very important for schools to educate all of their staff about the importance of implementing programs. Another frequent exclusion is not letting students with disabilities participate in field trips or extracurricular activities. Another one of the letters, Dear Colleague letters, specifically addresses extracurricular activities. I had a personal experience where a school district was not letting their deaf student go to the outdoor ed programs because they would have had to provide an interpreter. And when they were advised that they were discriminating, they immediately changed that. But all students have a right to participate in extracurricular activity. That includes your football team. Making decisions unilaterally could sometimes result in a request for a hearing. In other words, the administration of the school has made a decision, but they have not included the parent in that decision. The decision has to be one that all parties are participating in. And they're making decisions that are not based on the evaluations or the information or the child's needs, or not affording parents procedural safeguards sometimes results in a request for a hearing. The next issues that I'm going to cover are actual ones that came from two attorneys who work for the Office of Civil Rights, Jacob Smiles and Gail Sikowski. Jacob was out of the Denver office, Gail was out of the San Francisco office. Both of them, as it happens now, Gail is retired and Jacob is now a judge. But these are some actual cases that they cited for me that the Office of Civil Rights were confronted with as far as due process issues that were not being addressed. Again, and they're similar to the ones that I've just addressed. Failure to respond to a request for an evaluation or to independently identify a student with a disability who should be evaluated. If the school district is aware that a student has a disability or suspects the disability, they have an obligation to evaluate that student. And that includes students with mental health impairments. Failure to document the Section 504 team decision regarding eligibility. Again, this is similar to the one before, that they're not documenting it in a proper manner so that the parent has a record of it. And it's important for the school district to have a record of it, so it must be documented. Failure or refusal to consider outside evaluation. Again, parents have gone to the trouble to have an evaluation done by a private individual. The school district they have an obligation to consider them, and may not necessarily use them, but they do have to consider them. Failure to develop a plan for students with medical disabilities, such as diabetes or allergies. Frequently, school districts feel that a healthcare plan may cover this, but it's not adequate. So you must fully address students with medical disabilities as well. Awareness that students may be disabled under Section 504 or Title II of ADA and entitled to special services in a regular program or special education, even though they do not qualify under the IDA. In other words, we have students who have a disability, but they don't qualify. It's not one of the 13 disabilities specified under IDA. And those students must be eligible as well and must be served. For more from the Office of Civil Rights, evaluations of, again, students with attention deficit disorder. You'll read more about that later. Failure to conduct behavioral assessment. Failure to implement a student's IEP or Section 504. This is probably the one that I get, most of the hearings I get are a failure to implement the student's Section 504 plan. Failure to allegations that a parent has alleged that they are being discriminated against. Or exclusion again from extracurricular activities, evaluations are not properly identified. So these are actual ones from the Office of Civil Rights. As mentioned, named Perry Zerkels. Perry also has his own list. And the most prominent one he has is offering a 504 plan as a consolation prize. In other words, what happens is a student is evaluated for special education, not found eligible. They don't truly qualify for a 504 plan, but the districts will offer it as a consolation prize. Perry refers to this as a 252 plan. In other words, half of a 504, but it should not be done. The student must truly have a disability and it must affect one of those major life activities. Requiring the parents to obtain a medical diagnosis at their own expense. If you want a medical evaluation as a school district, you better get your checkbook out. You cannot require that the parent pay for it. Using a small subset of learning to determine the eligibility. And so I wanted to cover some tips for you from Julie Weatherly. Some of you may know that Julie. Julie is an attorney in the Southern States who does a lot of work in special education in 504. She actually has, these tips are taken from what she called she has 90 tips. I have taken 9 of them that I wanted to share with you, and I'm sharing you with her permission. But these are things that you need to do to be aware of. Number 1, you must review your district Section 504 and procedures. Look to see, do you have a school board policy relative to the Rehab Act and Section 504? Have those Section 504 procedures in place and train your school personnel, all of your school personnel, not just your special ed teachers or your teachers, but your related services staff, even your custodian. You must understand that a student can be found disabled under 504, but not need a plan as well. As long as you can serve a student, a student's disability may be adequately served within the regular education program without a plan. And actually, a 504 plan, a written plan, is not required by the law. It's recommended, but not written. Remember, there are special rules of discipline also, just like in special education. If a student on a 504 plan commits an act that is expellable or suspended, you have to do the whole manifestation determination just as you do for regular ed. Avoid exclusions or otherwise from again, this points out, have a procedure that all of your students are eligible to participate in the activities, all activities. Be aware that developing, as this was mentioned earlier too, that a health plan may not be sufficient to accommodate a student with a 504 plan. It has to be much more specific. And remember that learning is not the only major life activity. You look back, you saw some of the others under that chart. By the way, that chart is one of the resource guide as well. Also recognize that bullying can be considered discriminatory and it can be found if a student has a 504 plan, is being bullied. That's discriminatory. There's another Dear Colleague letter in the resources for you regarding that. and also then be fully aware that recognize that the potential for Section 504-based lawsuits alleging retaliation. Now, this is not just, when you look at the Rehab Act, as I mentioned, it applies to students, but it also applies to all employees as well. So you need to be aware that retaliation could be a possibility. eLuma is going to provide you all these resources. This is the resources that will be covered within, you'll get this, and each one is a document that will be very valuable to you. The first is a sample board policy regarding hearing procedure. It's actually a board policy that was developed by a law firm. You also then have the 504 Q&A. These are the 42 questions that I referred to earlier. OCR came up with the answers to them. It covers everything from identification, evaluation, placement, due process. It covers everything. So be sure you take a look at that. There's also an article by OCR defining what FAPE is, Free Appropriate Public Education under 504. You have guidelines for 504 under the Department of Education. You have an article, The History of Section 504, that was written by an attorney in Southern California. I've also included in this, the handout, 2 documents from New Hampshire. They are handbooks. One is a hearing officer's guide for 504. The other is a model user's guide. Those complete documents will be provided for you. You can print them out yourself. There's also, I mentioned the disability defined chart. That'll show you the 504 disability eligibility statements and the categories. There are three letters that will be in the file for you. There's the 2 Dear Colleague, they're called Dear Colleague letters. One addresses attention deficit hyperactive disorder. One addresses the bullying issue, and one addresses extracurricular activities. There's also a parent and educator resource guide that the Department of Education just put out in 2018. It's an excellent guide for all parents and educators. It is, you have it, you can print it out yourself. It's excellent. I've also included as a sample from the Florida Department of Education, the procedural safeguards. It sort of outlines what Florida does. Every state should have their own procedural safeguard. I've also provided for you in this resource the actual Rehabilitation Act, so you'll have the actual content of the law. Also included then are the regulation. As you're probably aware, anytime we have a law passed, first you have the law or the act, that's the content. Then the government has to develop regulation. Just as with our special ed, we have the special ed law, we have special ed regulation. So you have, I'm provided for you the Rehabilitation Act in its entirety. Also I've provided for you the regulations in its entirety. There's also a sample for Section 504 due process hearing procedures. This was actually developed by Parental. It's what I use when I'm doing a hearing. It's what I send out to the parents and the districts telling them exactly how the hearing is going to be conducted. It addresses timelines, it addresses evidence, the witness testimony. It covers how the decision is going to be enacted and who's responsible. So that's in this resource that you'll be receiving. Then you also have an article on special education due process. There's also an article on due process hearings and one on procedural safeguards. So all of these will be in a resource that's going to be provided for you by eLuma. Basically, rather hurriedly, but that's the information that I have to share with you. If you feel a question, you're welcome to contact me. There's my email address. I'm more than happy to respond to you. So with that, I'm going to turn it back to Jeremy because he's going to discuss the question and answers.
Jerry, thank you so much. Sincerely, it is a pleasure to have you here.
It's been my pleasure.
I know that we have had a feast at your table today. You have set a very plentiful meal for us. Anyway, I really appreciate that Jerry has taken the time. He's incredibly knowledgeable, as all of you can tell. we're going to transition into a Q&A that will wrap up our webinar today for all of you. And the Q&A comes with questions that each of you have asked throughout the webinar and are in the chat. So the first question that I would like to point out is here from some district staff members. And it says, please discuss how a child qualifies for related services such as speech therapy when they didn't qualify under IDEA. All speech therapy is specialized instruction. So how can the services be given under 504? Or is a 504 for accommodations only, outlined by the speech pathologist? Jerry, you want to give that a go?
Well, I would question if a student is exhibiting a speech problem, a speech that some type of disability in the area of speech as determined by a qualified speech therapist, and the American Association of Speech and Hearing has some very specific requirements. I would question why a student could have qualifies for services but not be provided under special education. To me, that would be a reason for a hearing, because I do not see a situation where a student who is eligible for speech services would only receive them through 504. I would refer that back to the district to say, this is, you may want to consider this for a hearing.
Perfect. Thank you so much. So the next one is short, but it says, to be clear, the funding for 504 comes from the general fund, right?
That's correct. Under IDEA, you have federal funding and state funding to support your programs. As I mentioned, it's not necessarily the 40% they guaranteed some 40 years ago, but under Section 504, there are no funds available. So if you have a student that you must make an accommodation for, whether it be transportation or whatever accommodation you must make, you're going to make that, but you're going to pay for it out of your general funds. There are no dollars attached to Section 504.
Perfect. There are a couple more and we have some time, so let's keep going. Another individual in our webinar asks, can a parent object to the hearing officer that is selected?
Yes, they can. And they would have to, if they were objecting to the hearing officer, I've never had this happen, but my take on it would be that, yes, they could object to the school district, and what they could do then, they could file a complaint with the Office of Civil Rights. That's how I would see that it would have to be handled. If the district doesn't remedy it. If the district did oblige and have a different hearing officer, then yes.
Perfect. There is a little side note. We have had several questions of how do we get resources. To be clear, after this webinar is over, eLuma, we will distribute a recording of the webinar, a copy of the slide deck that you've seen today as prepared by Jerry, and then also the resources that he referenced at the end of his presentation.
All of those resources are online. You can just click on them. You'll find them.
All right, let's go to the next question. I'm doing these in order as they came in. So hopefully we'll get to as many as we can. Let's see. Who qualifies as a change of placement for a 504 student? Sorry, what qualifies as a change of placement for a 504 student?
It could be a change from one school to another. It could be a change from removing them from a specific class or an activity that they're involved in. Something that is something changing in their program that's being provided that for some reason the school district is changing. Probably the most common one is changing from one school to another. But otherwise, it's something in their program that has changed, whether it be a class, a service, provision. For example, maybe a student is provided extra time to go to the nurse's office to take a medication, and suddenly they're no longer providing that. That would be a change in program. So anything that's going to make a change in the student's program.
Thank you, Jerry. There's a question that actually piggybacks off of the first question that we had about speech therapy. It's right over here. It says, piggybacking off of the first question, what about OT or PT through a 504 plan? You cannot have standalone IEPs for OT or PT. So that's back to this first question as well.
Well, I think what you would look at with OT and PT is that under special education, they specifically address educational performance. You may have a situation such as a student who needs physical therapy, but he is not being impaired educationally. It's just maybe getting around physically or something. So a student who doesn't require special education services, but does require something special, whether it be physical or occupational therapy. So yes, OT and PT could be a provision in a 504 plan that a district is providing. Now again, you have to remember there's no funds available for that. So you're going to provide it at your own cost. So it's, yes, a student can have a disability that doesn't qualify for special education, but they still have to have accommodations for it.
So there's a similar follow-up. Would a school district be required to provide OT services for a 504 student who does not qualify for an IEP?
Yes.
So I think we just answered that question as well.
Because the student, you look at the category under IDA, there are 13 eligibility categories, but under 504 is much broader. So you can have a student with a disability that doesn't require special education services, but may need some other kind of accommodation, whether it be maybe time between classes, time on doing tests, maybe being excused from a PE program because of it.
There's a question here that I think is important for us to address and maybe resolve some possible confusion. The question here is, are you saying that students can be both? In other words, have an IEP and a 504?
No.
Right.
One of the questions in, it's question number 36, when you get the question and answers from OCR, specifically addresses that if a student has an IEP, they do not need a 504 plan. All of your, actually, the 504, IDA is going to provide much more services than you will 504. So an IEP, you don't need a 504 plan.
Well, Jerry, I think our time has come to an end. We have a lot more questions, and I want to acknowledge the wonderful questions, the incredible engagement that we've had from all of you out there. I wish that we had another hour to go through. We could just dive deep into Jerry's mind and his knowledge. But we do have to close up, and we are going to send out some more information. We will provide some answers to the questions that we did not get to. Now, before you leave, please stick around for 2 more minutes. We're going to put up a poll because we want to hear from you about future webinar topics and what would interest you. On your screen, you'll see a question that says, which topic would be the most interesting for a future webinar? It is multiple choice. The first one, shortage and turnover in special education. The second option, compliance strategies. The third one, improve your retention. The role of technology in special education. How telepractice can elevate your progress. Go ahead and fill that out as you wish, and as you do so, I would like to mention that in the follow-up and as we provide these resources, we will invite you to schedule a visit with one of our qualified eLuma specialists, and we'd love to answer any additional questions and provide you with more information. eLuma licenses our services and our software for speech therapy, occupational therapy, mental health services, and we do it in a blended model so that your on-site district staff can blend with your online remote staff and create a very productive and effective model for special education. Thank you so much for filling out this poll. We have gathered data about the topics that are interesting to you. It looks like compliance strategies comes out as the lead, and shortly thereafter we have how telepractice can elevate your programs, shortage and turnover in special education. So we will go ahead and make note of that. Thank you so much, everybody. We have enjoyed your presence. We have enjoyed being together today, and we look forward to interfacing with you again very, very soon.